Yeah, Bill Henshaw here again, continuing our introductory new YouTube channel, Win in Court. And we're now going to discuss the motion to dismiss, an important tool for you to know about and one you can use to quickly take control of your case. This will not actually discuss the filing of the motion. That's covered in the information documents available in my constitutional defense documents, and information available on those at youwinincourt@gmail.com. That said, let me read you something about the motion. Now, here is a document that can win your case quickly, and that for a long time I did not believe could be done in a trial quote-unquote court, and certainly cannot be done by an attorney. After careful consideration of the matter, a rare area where there is no readily available ruling by the 9 old farts, aka the U.S. Supreme Court, I concluded that the massive amount of deceit, fraud, and even treason which can be proven to exist in the just us system was an affirmative defense, most particularly before a jury, to any claim of making a voluntary, knowing, and intelligent waiver of rights secured by the Constitution for the United States, 1787 to 1791. My reasoning on this very nuanced issue is on display in this motion and all of my documents available in my modestly priced constitutional defense documents. A big part of this change occurred when my petition for a non-statutory federal writ of habeas corpus was summarily quote-unquote denied by a deputy clerk of the California Supreme Court, with the notation that quote-unquote the position presents issues beyond the jurisdiction of California courts as they appear to present federal questions. A lot of trouble here was started by the exponential expansion of the Commerce Clause powers of Congress by the Supreme Court in the 1930s during the New Deal of FDR. Parenthetically, one might think that Truth in Government Actions would have required that notice be given that the deck was full of jokers controlled by the Wall Street banksters, and also at a time when the court was under constant threat of the court packing plan. Okay, this situation in which the Commerce Clause powers of Congress were recently invoked as justification for federal jurisdiction as taking a crap in a government-funded bathroom affects interstate commerce. And all of this ipsy-dixit act of judicial fiat was only accomplished by several 5-4 decisions, which in my view succinctly illustrate the venerable saying that the last temptation is the final treason, to do the right thing for the wrong reason. These decisions include the first ill-fated test cases of the social insecurity system, about which you will learn a lot more in later videos, and in the pleadings of my constitutional defense documents. But a good start to your studies here including reading the dissent of the Four Horsemen in NLRB versus Jones Laughlin Steel, 301 U.S. 1. Carmichael v. Southern Coal and Coke, 301 U.S. 395, and Steward Machine v. Davis, 301 U.S. 548, all available on request to me at youwinincourt@gmail.com. That said, I concluded the only way to raise my unopposed jurisdictional issues was to do so in the trial quote-unquote court, an unfriendly, nay hostile environment. Yet this preserves the right to petition the 9 old farts directly for review of a case from a traffic quote-unquote court, and in a situation where being heard in that court is not discretionary, as per the justices themselves in Cohens v. Virginia, 19 U.S. 264, quote, "The Constitution gave to every person having a claim upon a state a right to present his case to the court of the nation. However unimportant his claim might be, however little the community might be interested in its decision, the framers of the Constitution thought it necessary for the purposes of justice to create a tribunal as superior to influence as possible in which that claim might be decided." This is the type of power we have because the decision in your case decided on the record will provide a binding precedent for all like-situated victims of the just us system. It gets better. The local dumbass will not have a clue as to how to refute these claims and will not respond. Now, if we acted this way against the government motion, who do you think the quote-unquote judge would rule in favor of? In other words, case closed. And if the black-robed bastard rules against us here, this is an act of treason which should be reversed, earning he a suspended quote-unquote sentence by a jury of a type unlawfully meted out to Mary E. Surratt. Now, as an addendum to the video on the motion to dismiss, I want people to be quite clear that it's not me saying it. I have platinum authorities, and I want to read you one verbatim. I hope you're as shocked and as enamored as I was when I first read it, about the exponential increase in Commerce Clause powers. Quote, I shall not discuss at length the question of powers sometimes claimed for the general government under the clause of the 8th section of the Constitution, which gives Congress the power to lay and collect taxes, duties, imposts, and excises, to pay debts and provide for the common defense and general welfare of the United States. Because if it has not already been settled upon sound reason and authority, it never will be. I take the received and just construction of that article as if it were written to lay and collect taxes, duties, and imposts and excises in order to pay the debts and in order to provide for the common defense and general welfare. It is not a substantive general power to provide for the welfare of the United States, but is a limitation on the grant of power to raise money by taxes, duties, and imposts. If it were otherwise, all of the rest of the Constitution, considering carefully enumerated and cautiously guarded grants of specific powers, would have been useless if not delusive. It would have been impossible in that view to escape from the conclusion that these were inserted only to mislead for the present, and instead of enlightening and defining the pathway of the future, to involve its action in the mazes of doubtful construction. Such a conclusion of that character of the men who framed the sacred instrument will never permit us to form. Indeed, to suppose it susceptible of any other construction would be to consign all the rights of the states and the people of the states to the mere discretion of Congress, and thus to clothe the federal government with authority to control the sovereign states, by which they would have been dwarfed into provinces or departments, and all sovereignty vested in an absolute consolidated central power, against which the spirit of liberty has so often and in so many countries struggled in vain. That, people, is a quote from the Descent of the Four Horsemen in the case of Steward Machine Company v. Davis. And that's a recitation of the exact veto of President Franklin Pierce of the Social Insecurity Act of 1854. I have not found anything in the ensuing 90 years up until 1935 that makes any changes in what I have read here. Indeed, it makes Franklin Pierce look a lot like Nostradamus in his predictions of what's going to happen. This looks very familiar, exactly the situation we're in now, and he said it 170 years ago. Please remember to like my videos, to make comments, tell your friends, and I'll be happy to hear from you via email at youwinincourt@gmail.com. Let me know. I'm glad to discuss it.